Thanks very much to all of you guys for coming. The pre-law fraternity, thanks for sponsoring this. I don't know if all first-time authors go through this, but I definitely went through a process of sort of typing in the middle of the night while muttering to myself that nobody was ever going to read this thing. And then you find out you're going to get published, and then you go through this horrible realization that, oh my God, somebody's actually going to read this thing. It's been really gratifying, the response that the book has gotten, and it's really gratifying that you guys would take time out of your day, especially during the beginning of school when I know there's a lot of things going on, to come and hear this story. I spent about, depending on how you count, I started the project in 2004 and ultimately got published this May. So it's been a long process for me and a lot of time spent with this story. The reason that I did that and what made that easy ultimately and worthwhile is that I really do think it's an important story. What happened to John Thompson, the way he was represented by Michael Banks and Gordon Cooney, the things that were going on and continue to go on in the New Orleans District Attorney's Office, especially during the 30 years that it was run by Harry Connick Sr., the father of the famous singer and movie star. They're important issues, and they're important issues to think about, and as it turns out, circumstances have conspired to make this, I think, even more important and more timely a story than I could have known when I started writing this in 2004. So that's what I'm going to talk about. I've got some visual aids to guide the conversation, and at the end of that, I'll be happy to answer any questions. I will say at the outset, though, that you guys have demolished one of my metrics as I go on these tours and talks. One of my metrics has been the percentage in the crowd of signings of people that I know versus people that I don't. And I'm pleased that that metric has been steadily, the people I know have been steadily decreasing, the people that I don't at the readings have been steadily increasing. Today we have one person that I know in the audience, and so that's pretty good on both sides because A, I'm happy to see him, but B, he's the only one. Okay, so Killing Time starts on December 6, 1984, when a man named Ray Liuzza Jr. is murdered at 1 in the morning. He lived in sort of a sketchy area in New Orleans. I don't know how familiar you guys are with New Orleans, but often there's a really nice block next to a very sketchy block kind of throughout the city. Ray lived on the borderline of one of those areas, got out of his car one night to walk across the street to his house, was met by somebody with a gun. Ray was unarmed. The man was shot 5 times, 3 times in the back, robbed of a wallet that had no cash, a watch that was never found, and a ring that was later pawned for $6. He was left to die bleeding on the street, and there were no eyewitnesses to the shooting, although one man who was around the corner after the shots were fired reported seeing a 6-foot-tall African-American man running away, and the real tip-off for him was that the African-American man was holding an enormous blue steel pistol. So that was nobody actually witnessed the shooting itself, but we did see somebody fleeing from the scene. Ray Liuzza was a pretty well-connected guy in the city. There's a very popular restaurant in New Orleans called Liuzza's by the Track. His father was the owner of the International Hotel, which is where Ray worked. He was a former head of the City Chamber of Commerce. And the murder happened at a time when there was already a lot of popular anxiety about random acts of violence in the city. And so finding the killer and bringing that killer to justice became a real priority for the police and the DA's office. As I said earlier, the DA at the time was Harry Connick Sr. He's actually known as the singing DA. It's no accident that his son went on to become a jazz performer because that's been a real passion of Harry Connick Sr.'s throughout his life. He used to run a music store in New Orleans. He had a regular weekly singing gig at a New Orleans club. But Connick had a couple of policies that were pretty interesting at the time and fairly novel. One of those was that he would rarely plea bargain his cases. His view was that plea bargains would reduce the deterrent effect of sentences, and he would rather only bring cases where he felt he could get a conviction and then really take them to the charge he thought he could support, as opposed to plea bargaining. The other one was, in order to increase or try to reduce the number of murders in New Orleans, he had a policy that any time there was a first-degree murder conviction, he would try to seek the death penalty. Typically, in most states, and in Louisiana both then and now, in order to take a murder one conviction to a capital murder conviction, you have to have some sort of aggravating factor. It has to be done in a particularly heinous way, or as we'll see, you have to have somebody who has a prior violent felony conviction. And if you have that sort of aggregating factor, then you can take a regular murder charge and go try to get the death penalty in the sentencing. So it took about 6 weeks worth of investigating. So we're gone from December 6th now to January 17th, or January 17th, 1985. Nothing really happened in the case until the Liuzza family put out a reward of $15,000, put it out on the radio, newspapers, and leaflets around town. And then a number of informants, confidential informants, started coming forward. An informant named Richard Perkins in mid-January came forward, interestingly, not to the police, but to the Liuzza family, which I think is a clue to what his motivation was, and said that two men had separately confessed to the crime and the fact that they had both been present when it was done, and that each of the men had said that the other one was the one who fired the shots. The two men are here, Kevin Freeman on the left and John Thompson on the right. And police were able to trace from this informant, they were able to find what they claimed was the murder weapon. And they were able to trace the murder weapon back to John, that it had been in his hands before it had been given to the person where they ultimately found it. And so they arrested John and Kevin in mid-January 1985 and charged them with the murder. Now, because this was a big popular case and there was a lot of people in New Orleans following it, what the police did was they put those two mugshots on the front page of the New Orleans Times-Picayune on January 18th, 1985. And the NOPD phone started ringing off the hook with people who thought that Kevin Freeman and John Thompson had committed other crimes. One in particular call came from a man named Stuart Lagarde who said, John Thompson carjacked my 3 teenagers outside the Superdome at this intersection of Poydras and LaSalle in late December 1985. So early December is the murder, late December is the carjacking. We've now arrested John for the murder, and now we're going to arrest him of the carjacking. Carjacking was kind of interesting. I don't think I have a pointer here, so forgive me. But we're looking at the Superdome. We're going north on Poydras at the intersection of LaSalle, and you can see there's a median strip here. So the kids came out of a basketball game. It was a 19-year-old, 13-year-old, a 16-year-old, and a 12-year-old. They come out of the basketball game. They're parked here on the side of the street. And there are some similarities with what happened to Ray Liuzza. In this case, an African-American man with another .357 Magnum jumps in the car behind them, says, drive away, I'm taking your car. The 19-year-old boy is driving, and he says, take a right and go down into this industrial park. So what the 19-year-old does is, depending on your perspective, very brave or very stupid, or both. But he decides that with traffic coming out of the Superdome, he's not going to turn right, he's going to turn left. He's going to force a car accident. And then he's going to turn around and fight his attacker off from the back seat while his sister and brother get away. He's successful in doing this. The gun gets dropped. The attacker gets away. They're unable to identify anybody at the scene. And until John Thompson's picture comes in the paper, it's an unsolved crime. Once we get the call from their father, the DAs follow it up. Each of the 3 kids look, coincidentally, at the picture that was in the newspaper, which is the same picture used in the photo lineup to say, are you sure this is the guy? And they say, yes, it is. And so we arrest John on the carjacking as well. In the meantime, Kevin Freeman has decided that his best play is to give evidence against John Thompson and say, Kevin Freeman, was there. John Thompson fired the gun. John, for his part, says, I'm not a rat. I wasn't there. I don't know what you're talking about. I'm not saying anything else. So now you have the confidential informant who's come forward, you have the murder weapon with somebody who says they got it from John, and you have Kevin Freeman giving testimony in exchange for a plea bargain against John. And the interesting thing is John doesn't have any violent priors. John Thompson had dropped out of school in 10th grade. He'd kind of grown up in the projects. His father was a career criminal in and out of prison. The advice that he had given to John, his fatherly advice to John was, don't shoot anybody, just deal drugs, and you'll get short prison sentences, and then you can come back out and get back to work. And that was essentially the lifestyle that John was living, though there were some indications that there might be more to John than the average street thug. John had dropped out of school in 10th grade when he had his first son, Dedrick. 2 years later, he had a second son, John Jr. or Tiger. But John was working actually very hard to support both his sons. He had continued in his relationship with the mother of his child. He'd had a long-term relationship with her. And so there were some signals there that John was a guy who had some loyalty and had some deep understanding of family until the day that he was arrested and taken away. But he had no violent priors. And so the carjacking became a very important thing in John's prosecution. Now, the prosecutors did something that I think was very crafty and clever at the time. So you'll recall the timeline. December 6th is the murder. December 28th is the carjacking. January 17th is the arrest for the murder. January 19th is the arrest for the carjacking. So the carjacking is trailing the murder until April, when we try the carjacking case first. the DAs are actually able to control the schedule, the court schedule of when they try certain cases, and they accelerated the carjacking case. And they did this for two reasons. First, now they've got their violent prior, and they can go for capital murder instead of just murder one. And second, because of the similarities in the way the crimes were conducted, John's lawyers gave him what I think was actually very good advice, not to take the stand in his own defense. Had he taken the stand in his own defense, the similarities of the crimes, the carjacking and the murder, could have been used to prove his guilt in the murder case and made it look more likely that he was guilty in the murder. As it turns out, that wasn't enough to save him. He was convicted of the murder, he was sentenced to death, and he was sent to Angola Penitentiary in Louisiana to live the rest of his life in a 6-foot by 9-foot cinder block cell for 23 hours a day in solitary confinement. He was allowed to get out outside 3 days a week, out of the cell 1 hour a day for the rest of his life until he was executed in the electric chair. So let's fast forward now to 1988. John had another problem, which was he couldn't get a lawyer to take his appeals. John was politically radioactive in New Orleans because of the identity of Ray LaYuza and his father's connections. There were no lawyers who wanted to take the case. And so he sent letters out, hundreds of letters a quarter, letters that he got, or addresses to law firms that he got from magazines that were in the prison library, asking people to represent him. And for 4 years, nobody did. Michael Banks and Gordon Cooney, meanwhile, were two lawyers in Philadelphia who had decided that they really wanted to take on a pro bono case dealing with the death penalty. They had had a conversation with some other people in the firm about how best to use their pro bono hours, their charitable legal services hours. And one of the things they'd realized is that a lot of death penalty inmates can't get well-sourced, well-funded lawyers. These are very, very complex cases. They're very time-intensive. They're very emotional. They're very intellectual. The law around the death penalty is very complicated and very specific, and it requires a lot of resources. And most of the people that are representing death row inmates are court-appointed or public interest lawyers who have very little funding. And so the question was, well, what if we took the resources of a big firm? Michael and Gordon were senior associates at a law firm called Morgan, Lewis & Bockius, which is one of the top 20 law firms in size in the United States. They said, what if we take the resources of a big firm and we put that behind a death penalty representation? How would that change the outcome? Could we make sure that the right thing is done here? Now, to be honest, Michael and Gordon thought that John was probably guilty. I mean, the fact is, a lot of people who are convicted of crimes are guilty, and there was nothing in the record to suggest that John was innocent. But for Michael and Gordon, that wasn't really the point. The point was, number one, Michael had a moral opposition to the death penalty and wanted to do anything he could to show people that it was a bad thing. Gordon had a slightly different approach. Gordon's view was, I don't really know if I think the death penalty is wrong or not. Maybe somebody can do something that forfeits their right to be on the planet. But if we're going to do that, we have to make sure that the constitutional protections and the legal protections that we offer to people are done absolutely to the letter without fail. Those protections are there for a reason. We need to have them there. And before we take the ultimate punishment, we have to make sure that we're giving it the ultimate assessment of truth. And so these two men came together. They were in Pennsylvania, and we're going to take a case in Pennsylvania, but in Pennsylvania, the governor wasn't signing any death warrants. So they decided to go out of state to try and find some place where people were actually being executed because they thought that would be the greater good. Louisiana, in the 18 months before they took the case, I think had executed, I might be a little wrong on this, but I think they'd executed somewhere in the neighborhood of 13 people in the previous 18 months. So it wasn't Texas good, but it was a pretty impressive rate of executing people. So they got connected through personal ties to a clearinghouse in New Orleans that was trying to help John find a lawyer. And so you have the New Orleans death row inmate who needs out-of-state lawyers, and the out-of-state lawyers looking for somebody to represent in a place where it's meaningful, and this great convergence where they come together to try and take the appeal. So John ends up spending 18 years in prison, 1985 to 2003. I don't think that's a spoiler alert given the title of the book, but just so that you know, at the end of this, he does get out. 14 of those years he spent on death row. The last 4 he spent in maximum security prison, and you'll see why that is in a minute. During that time, John had 8 execution dates. Every time Gordon and Michael would take their appeal forward, there would be an execution date. They would get a stay, go to the next step in the appeal. That would get rejected. It was 1 step forward, 2 steps back. The trial court judge would then put another execution warrant on the table that Michael and Gordon would have to get stayed. And all the time, John is going through this process knowing that he's got a date, and the date's hanging over his head, and at some point that date's going to run out. He went through 8 separate execution dates. During that time, 12 of his fellow inmates went to the death house and didn't come back. Every time this happens, the guys are actually keeping pretty good tabs on one another, and they know where their cases are. Got a lot of time to talk. And you kind of have a sense of when somebody goes to the death house, whether or not he's going to come back. 12 times people that were on death row with John went to the death house and didn't come back, and he stayed and waited for his turn in that process. So Michael and Gordon represented John for more than a decade. And in April of 1999, the U.S. Supreme Court overturned their final appeal without comment, denied. There were no more appeals. They were down to a clemency petition from the governor, who had never granted a clemency petition before. And so they went down to Angola Penitentiary in April to tell John face-to-face that they had failed him. And it was particularly galling to Michael and Gordon to have to do this, because the John Thompson that they had come to know by 1999 was very different than the John Thompson whose case they had taken in 1988. They had gotten to know John as somebody who had sold his radio, literally his only worldly possession, so that his older son could take a class trip with his high school. They knew him as a guy who actually ran the sports book in the prison to raise money so that his mother and his 2 children could take a 5-hour bus ride in the middle of the Louisiana summer to come to Angola and visit him, so that his older son, Dedrick, who was then 12, could get turned away because he was wearing shorts, and only 11-year-olds and under could wear shorts in the prison. 12-year-olds had to have pants. But more than that, they'd gotten to know John as somebody whose mother and children would get on that bus and would come visit him, and somebody whose family was important, who was beginning to define himself with some philosophies of how he was going to live his life, who was getting rid of some of the anger that he'd had as a street tough, and was dedicating himself to being the best father that he could and the best person that he could in an environment where literally a lot of people are very, very quickly driven crazy. And so to be at this stage and feel that they had let this man down, maybe he was still guilty, but certainly they felt that his life was worth saving. And so it was a very, very difficult and emotional time. In a sense, John didn't make that any easier for them, because John had 2 reactions to being told that he was going to die in 30 days. His first reaction was to try and take care of Michael and Gordon and say, you guys shouldn't feel bad. You did everything you could to me, and this is the life that I led, and I put myself in a position where this could happen to me. The second thing he said was, do you think we can move the execution for 4 days? Because John Jr. is supposed to graduate from high school on April 20th. He'd be the first person in our family to graduate from high school. And I don't want my execution to interfere with his ability to be proud of that feat. So if you could just push it off 3 or 4 days so that my son can have his high school graduation without this hanging over his head, that would be really great. Michael and Gordon left the prison and were on their way to the city of New Orleans to find John's mother and tell John's mother that they had failed her son and that her son was going to die in 30 days. Gordon checked his voicemail and got a phone call from a private investigator that they had hired in a last-ditch effort to see if there were any new facts that they could turn up that might change things. The private investigator had gone into the New Orleans Police Department evidence vault and had been going through microfiche around the time of the crimes, 1985, so 14 years ago. She found a blood test that had never been disclosed, conducted by the DAs in the crime lab, never disclosed to John's original attorneys, never disclosed to Michael or Gordon, despite numerous requests for any scientific evidence they might have. This blood test is actually taken from the carjacking case. So you'll recall there was a fight between the driver of the car and the carjacker, and in that fight, there was some blood spilled on the pants and on the tennis shoe of the kid who was driving the car. So what you see here is, this is the actual blood test itself. That's clip art down there. And one piece of the victim's pant leg and one tennis shoe were tested. The tennis shoe blood was not ultimately testable, didn't yield a blood type. But the pants sample yielded positive serological reactions for group B blood. So either the carjacker or the kid driving the car had type B blood. Now, Michael and Gordon then started kind of peeling away the layers of the onion here. There were 3 prosecutors who were running these cases, and the junior one was a guy named Jerry Deegan. the police are required to have a custody card for evidence that says who's handling the evidence when to make sure that we know where it's gone and people aren't tampering with it. Jerry Deegan had checked out the pants leg and the shoe, taken them to the crime lab, and then picked them up at the crime lab and checked them back in. And then the next day, checked them back out again. And that's the last anybody ever saw the pants leg and the tennis shoe. But now we have this blood test that presumably they thought they had destroyed, but hadn't. And so Michael called Jay Lagarde, the teenager who was in the car, and his blood type was O. And then they called John, and they got John's medical records, and John Thompson's blood type was also O. So there was no way that John Thompson could have been the carjacker in the crime that did, again, two things. Number one was the justification for the death penalty, and number two, kept him off the stand in his own defense in the murder case. Now, Harry Connick Sr., and we'll talk about this more in a minute, said, well, I'll give you the armed robbery conviction, but I'm not going to say that he didn't do the murder because the blood test doesn't show that. And that's true. And so it took Michael and Gordon 4 more years to get a retrial on the murder case on the basis that John would have taken the stand in his own defense and the jury would have seen a very different style of things. There was a lot more new evidence that was discovered in that 4 years, and I'll get into why in just a moment. But the key here is John finally was able to tell his story, and a jury was able to hear all of the facts in May of 2003. And John was acquitted after less than 35 minutes of jury deliberation. I don't know if any of you guys have ever been on a jury, but I can tell you that 35 minutes of jury deliberation is like, hey, are there sandwiches back here? This guy's innocent. Let's go back out and tell the judge. So let's go back to Harry Connick a little bit and talk about the Connick DA's office, because I think it's important for a number of different reasons. As you might expect with somebody who tried to put a death sentence on every murder one, Connick put a lot of men on death row, 36 men during his 29-year tenure. 19 of those had what's called Brady allegations. Brady versus Maryland is a Supreme Court case that requires prosecutors to turn over exculpatory evidence, material evidence that might lead a jury to believe that somebody is innocent. They're required by law to turn that information over to defense attorneys without a request, regardless of whether they think it's exculpatory or not. They have to give that to the defense. There have been no fewer than 19 different allegations made about Brady. 9 of those have been upheld by courts. Now, most courts will go to great length to avoid publishing a written opinion that criticizes a prosecutor's office in writing for failing to turn over exculpatory evidence, even if they believe it's there. So the fact that there are 9 of these that have been upheld in writing is an astonishing statistic. It's a very, very troubling statistic about what's going on there. And what it means is that 5 of the death row inmates of the 36 that Harry Connick put on death row, 1 in 7 was either pardoned or exonerated, had their sentences taken off death row, reduced to life. That's, I think, not a statistic that is something that we should be proud of or be striving for. I said there were 3 prosecutors on the case. Jerry Deegan was the junior one. The other 2 were a man named Eric Dubelier, who was the number 3 guy in the Connick DA's office. He also was married to Connick's niece. And so I'm interpreting the data here rather than having somebody tell me this, but my interpretation of that piece of information is Harry Connick was saying to the Liuzza family, I got my family on this. I'm keeping very close watch on this. This is important to me. So Dubelier was the special prosecutor assigned to the case. But this is Jim Williams. Jim Williams was probably the most experienced homicide prosecutor in New Orleans at the time of the murder. And he was the prosecutor for both the carjacking case and the murder trial. This is a picture that was taken by Esquire magazine on a profile they did on him in 1995. You can probably find it here in the library. And what you have here is the prop that Jim Williams decided he wanted to be photographed with. This is a miniature, battery-powered, 12-inch working electric chair. If you were to touch that chair with your finger, you'd get a shock. And in it, in the paper clips you see are the little headshots of the mugshots of the men that Jim Williams had personally prosecuted and put on death row. Now, Williams went from the Orleans Parish DA's office, where he worked for Harry Connick, to the Jefferson Parish DA's office, where he worked for Harry's nephew, Paul Connick. There they had gone from the electric chair. By that time, the state had moved from the electric chair to lethal injection, and so the electric chair wasn't as funny anymore. What Williams did was there were awards, and this is all detailed in the Esquire article. There were awards that he and his colleagues would give out to each other. They were big hypodermics on a plaque, and they called them the Big Prick Awards, and that was the award that they gave to each other for getting a death penalty conviction. But I think this is really the important feature of that picture with Jim Williams, which is, for various reasons, none of the men that Jim Williams put on death row and paraded around in his office in these pictures are still there. Not all of them are out of prison, but all of them are out of death row because of problems that were in their trials from a legal perspective that needed to be addressed. So John was released in 2003 and has gone on to do some pretty incredible things with his life. He's actually started a foundation called Resurrection After Exoneration and has become a thought leader in problems of avoiding prison recidivism. The rates of somebody like John going back into prison after that amount of time and incarceration are upwards of 85%. John has not only defied those odds, he's started a foundation, gotten it funded, bought a house in New Orleans, and now has room for up to 15 released convicts or exonerees with a program to help them get their lives back together. It turns out that we have fewer social services available for people who've been exonerated than we do for people who've been released after a conviction or paroled. The theory is you couldn't possibly be institutionalized, you didn't do anything wrong in the first place. We also, in John's case, he didn't even get the VOTEC resources that the average prisoner would get during his time in prison because we don't allocate those resources to people that we're going to kill. So John really had nothing to start from. In fact, one of my favorite stories, this is not in the book, but one of my favorite stories is the night he was released from prison, Michael and Gordon and Morgan Lewis ended up putting John up in a hotel for about 3 months so that he wasn't going back into the street environment where he would be at high risk. And the first night, Michael handed John the key card for the door, and John said, "Oh, thanks, what's this?" And Michael said, "It's the key to your room." And John said, "Brother, I've been in prison for 18 years. I think I know what a key is." I mean, he'd just never seen one. He'd never seen a soda machine. You know, there were all sorts of things that he had to figure out how to do really from scratch. And I have to say, it would be very disappointing from my perspective in writing the book, and it would be much harder to tell the story if John had gone back to prison 2 years later on something else. So I'm delighted that he has made so much of his life. Not surprised in any way, but really delighted. But the story actually gets more interesting than that. Michael and Gordon continued to represent John, and in 2005, they filed a lawsuit on his behalf in federal district court in New Orleans against the DA's office and against Harry Connick, Eric Dubelier, Jim Williams in their individual capacities. And it's very difficult to sue a prosecutor, and there are a lot of very, very good reasons for that. You don't want a prosecutor who is doing their job and trying to find guilty people and mete out punishments that fit the crime. You don't want that person to feel like if they're wrong and somebody gets acquitted that they're going to get sued. So you want to have that bar be high, and I think that's appropriate. But Michael and Gordon thought this is an extreme case. What's happened here is a travesty, and there needs to be some accountability for an office that operates the way the Connick DA's office operates. So they filed suit on a pretty novel theory, and the theory was that the office was responsible for John's incarceration. The district court awarded John a $14 million verdict. Now, that probably translates, one way to think about that is he spent 18 years in prison, but he spent 14 years on death row. So one way to think about that is $1 million a year for the time that he spent on death row. Because when John was released, by the way, I used to, actually I've been overselling this point, I used to say John got $10 in the clothes he was arrested in, but that was wrong. He didn't get $10. He was released from a different prison than the one that would have given him the $10 administratively. So he really got released with nothing. And so there are two ways that John might get some compensation. One is this case, and the other is that John gets the proceeds of the sales of this book. And hopefully both of those will do well for him, because, as I said, he's doing some great things. But they won this $14 million verdict, and the DA's office in New Orleans has appealed that decision. And amazingly enough, it's gone all the way up to the United States Supreme Court. So on October 6, 2010, the case of Connick versus Thompson is going to be heard on the issue of whether John is entitled to his recovery. And what's really at stake, in my view, is what tools we have in our toolbox to be able to hold the government responsible, our municipalities and our elected officials accountable when they commit deliberate dereliction of duty. The finding of the court, of the jury in New Orleans, was that Harry Connick had been deliberately indifferent, had deliberately turned his back, as evidenced by a pattern and practice of behavior, on the obligation to train his lawyers about how to handle evidence and turn it over to the defense. That he had consciously and deliberately decided not to train people properly on that, and that that was a knowing and direct cause of John's suffering. This is actually a picture of the Orleans Parish Criminal Courthouse, and what I love about this picture, I noticed it when I visited there doing research for the book. I don't know if you can read the inscription cut into the marble up top, but it says, "The impartial administration of justice is the foundation of liberty." And the irony that the Connick guys walked in and out of this courthouse every day, I bet if you asked any of them what the inscription was on the top of the courthouse, I doubt any of them would be able to tell you, but certainly that wasn't the way they played the game at all. So I think it's going to be an important case. What's really kind of amazing to me is this is an article from the Times-Picayune. You can see the date is August 23rd, 2010. So this is 3 weeks ago. 3 weeks ago, a new case came to light about a guy named Booker Diggins. Booker was arrested of rape and robbery in 1988, and different DAs in Connick's office conducted a blood test and had some DNA samples, and we just discovered that 3 weeks ago. So this isn't an isolated problem, which is even more frightening than if you consider John's story. But it raises sort of an interesting point, which is, why did John Thompson's case get discovered in 1999, where Booker Diggins doesn't get discovered until 2010? And the answer is, in a very real way, the death penalty saved John Thompson's life. Without the death penalty, Michael and Gordon don't accept this case. Without the death penalty, they don't put the resources of a big law firm behind it. And even with their passionate representation, and even with all those resources, it was the 11/59/59 discovery of the blood test, which no court-appointed lawyer would have been able to fund or think about, that saved John's life. Booker Diggins was just in for life in prison, and if it wasn't for Barry Scheck and the Innocence Project having created clinics around the United States to try and take on some of these cases, Booker Diggins would still have the same problem. And so you got to wonder, how many cases are there like this that are out there? And how are we going to discover them, and what do we do about it? And when you start realizing that we're still discovering cases from 1988, and we've got, I don't know how many of these cases, 9 Brady violations, 5 death row people taken off death row, John Thompson, Booker Diggins, and that's just in Connick's DA's office? What kind of problem do we have nationwide? And that's why I think it's so important that people understand the Connick v. Thompson case and understand the importance of having something, some way to hold DA's offices accountable, because what the New Orleans DA's office is arguing is absolute immunity from prosecution, that there is no circumstance where the DA's office should be responsible for the acts that are taken by its prosecutors or by Harry Connick as the lead policymaker in that office. I think it's a challenging position for them to take. So this is John today. This is actually a picture taken when he was going through a training program with Echoing Green. Echoing Green is a group that has funded him. They're related to the Ford Foundation, and they're a very, very demanding fundraising group. So it's a real coup that Resurrection After Exoneration has raised money from them. And I think what he's doing is nothing short of spectacular. I would encourage you to visit r-a-e.org and see what Resurrection After Exoneration is doing in New Orleans, because a lot of people are starting to pay attention to it, and it's pretty exciting. So that's the end of my remarks. I really enjoyed writing the story. It's been a real privilege to get to know John, and the relationship that emerged between John and the lawyers, which I think hopefully the book captures well, is something that will be worth your reading, and I haven't given too much of the story away. But I very much appreciate your time. I think it's a gripping story, and more of all, I think it's an important story. So I'm really glad that you've allowed me to share it with you, and I'd be happy to answer any questions that you might have. Yes, sir.
Were the trial attorneys public defenders?
The trial attorneys, no. There were 2 court-appointed trial attorneys, one of whom was a private criminal attorney. The other one was a private corporate attorney and sort of entrepreneur. And so one of the judge appointed the corporate lawyer who said, "Judge, I'll do this if you want me to, but I really don't know this area of the law. Can you give me a criminal lawyer to work with me?" And so that's how they got on the case. But they were court-appointed, but not defenders.
You had mentioned the importance of not withholding scientific evidence. There was the Cameron Todd Willingham case a few years ago where he was executed due pretty much to a failure to obtain scientific evidence, which would have exonerated him. How do you think that relates to this issue?
Well, scientific evidence, it strikes me, as either attainable or not. If it is attainable, within the rules of procedure, you should try to obtain it, right? I mean, but I don't know the particulars of the Cameron Todd Willingham case.
Right before he was executed, a renowned arsonist or arson investigator went and analyzed the issues of the case and proved that it couldn't have been, or that it was an electrical fire. Whereas the original fire investigators, who never studied any of the science behind fire, the true science, had decided outright that it was clearly evidence of gasoline use instead of this fire. And nobody went around getting it until this guy read about the case in the New Yorker and went and started his investigation.
Well, so I think you're describing a situation that sounds like a very common situation with a defendant who's already been convicted, right? It's very difficult for that person to get representation, and even if you had a public defender, the resources to obtain some of that information are very, very difficult to get. And so there is definitely sort of an economic disparity in the people who can pay for private lawyers and big firms, and people who have the wherewithal and the resources to do this are able to go out and acquire that stuff, and other people aren't. And I think that's a problem, certainly. How it impacts different cases, obviously, is a fact-specific thing. One of the things that attracted me to this story was that DNA evidence, for all of its benefits, is really only usually available in about 10% of cases. There are an awful lot of cases where circumstantial evidence and eyewitness testimony are used, which is what was done here, to convict somebody. So it's certainly a challenge to get scientific evidence, but for me, the bigger fear is when you don't have that scientific evidence, what are you going on? How do you know it's reliable? What do we do to protect people in that situation? Though certainly you want to gather whatever evidence you can so that a trier of fact can make the right decision.
I have two questions. One is the Philadelphia lawyers, what kind of law did their firm typically practice? And also, how did you come to find this story?
Okay, so the two questions are, how did the Philadelphia lawyers, what did they do for a living in terms of the practice of law? And the second one was then, how did I get involved with the story? So Michael and Gordon both practice law at Morgan Lewis, which is a large corporate law firm with lots of different sections. Gordon is a litigator who has predominantly a securities law practice and a product liability practice. He'll actually be arguing the case before the Supreme Court on the 6th. Michael is a labor and employment law attorney working on the company side, so typically representing companies in their labor and employment law practices. But both of them are litigators in the sense that they do things in court regularly. I actually was an associate at Morgan Lewis, and so I had gotten to know Michael and Gordon while I had worked there for a couple of years in the mid-90s. And so I had left the firm and started doing healthcare things in the late 90s, but was in close contact with Gordon and Michael and began to pester them about writing the book really when the blood evidence was found. And then in 2003, when they finally got the retrial and you really had the big suspense-filled crescendo of the second case and how was it going to go, and the incredible ending of acquitted very quickly, and John being reunited with his sons, then I really laid on the pressure and said, you guys got to let me write this as a book. And their condition was, yeah, we'll let you do it, but you have to take care of John, and he's got to benefit from the sales of the book, because at that time and even now they didn't know whether there would be any other way for John to get compensated for this. And in fact, it will be interesting to see. I mean, I dearly hope that the right thing is done at the Supreme Court. How you get $14 million out of post-Katrina, post-BP New Orleans is going to be an interesting question.
What happens if Connick wins his appeal?
Well, so if he wins his appeal, then and it's him in his official capacity. So let me be clear there. It's really the Orleans Parish District Attorney's Office, just to be precise. Then the verdict is overturned, and thanks for playing John.
So he doesn't get his 14 million.
That's right. And I mean, the presumably then you've got to, if John's position prevails before the Supreme Court, then the New Orleans government, the Orleans Parish, has to figure out a way to come up with that $14 million.
Can you talk a little bit about the procedural hurdles that somebody on death row faces? As I understand, there's like certain things that the appellate court can take into consideration, like they can't retry the case fully. They have to kind of look at specific things that.
Yeah, so, I mean, I think that's a big part of why it took until 1999 to find this blood test. Michael, as an appellate lawyer, you are restricted to errors of law, errors in the procedure of the trial, misapplications of the law of evidence as to what can and can't be shown. But a jury has decided, in fact, there's a chapter in the book called "The Truth is What the Jury Says It Is," right? Because a jury is a finder of fact. The jury's job is to determine what were the facts. And once the jury has said that, then the facts are established. And you can argue about the application of law on the facts, and you can argue about whether a jury might have found different facts that would have led to a different outcome if the blood test had been out there, right? But you've got to have some basis for arguing that that's legal in nature. And so Michael and Gordon, you know, they asked about other evidence that they might be able to use. It didn't happen, and their job was to focus on the law, not to retry the case, but to make sure that the case had been managed properly from a legal perspective, and that was really what they were limited to. So it wasn't until all of that was gone and there was nothing else they could do that the private investigator went and dug for this. Because keep in mind, they'd asked for this information in 1985, and they'd been told it didn't exist. And so that was definitely a challenge. But to me, one of the things that was really gripping about this story is you look at the facts in 1984. I mean, you read the trial transcript in 1984, and you're like, yeah, okay, this guy's guilty. He did it. And then you read the trial transcript in 2003, and there's all these new facts. So there's actually something that I skipped over in the presentation that I really should say right now, which is Connick had another policy that was a problem. The policy was he was not a proponent of what's called open file discovery. So open file discovery is the theory that you take your whole file when you're the prosecutor and you just hand it over to the defense. These are all the facts we have, all the witnesses we talk to, all the whatever. We think, prosecutors, that this is enough to try this guy on and convict him on. But here it is. We're not hiding anything from you. Connick didn't believe in that. Connick wouldn't turn over things that he didn't think he had to turn over. He was concerned about witnesses being, potential witnesses being identified and being at risk, and a lot of other justifications. But in particular, when police are doing an investigation, they have daily police reports that they file out at the end of their day that captures the investigation. And then there's a summary report that they put forward that summarizes the whole case. So the analogy that always made sense to me is that the dailies are like a diary, and the summary is like a memoir. The diary is what you write in every day, and you don't really know where it's going, and it's your thoughts, and it's a lot probably more direct and honest. The memoir is how you want to be remembered. And so it's not surprising that once you know who you're going to take to trial, that all the facts in the summary report lead you to John Thompson. When Michael and Gordon got the dailies, the way this worked was they brought the blood test forward, and Judge Quinlan in the criminal court went ballistic on Connick. He wouldn't order a new murder trial, but what he said was, give them everything. You now have open file discovery. Congratulations. Turn it all over. The dailies arrived in Michael's inbox one day, and all of a sudden there were a dozen new pieces of evidence, new witnesses that the police had interviewed that he'd never heard of before, that he'd never seen before. And all of this had been in the dailies and was known to the DAs, was known to the police, but never turned over to John's defense attorneys. And using those witnesses, they were able to put a whole new theory of the case in 2003. And that's what led to the rapid acquittal in 35 minutes. And so we say the truth is what the jury says it is, but in fact, the jury only says what the truth is based on what they've been allowed to see. And so, for me, when somebody's face gets put up on CNN as guilty of X, I think to myself, really? Maybe. Hard to know. I wasn't there. And I think all of us on a jury or anywhere else have to have that hesitation. You have to kind of make sure that you keep that in you that sort of says, maybe. A lot of people are guilty. People do bad things. Are we really sure? And how are we really sure? And how do we fix it when we make a mistake? And those are all really important issues that this case and the story bring up.
So, either way the case is decided, what do you think, how can we improve prosecuting offices? I mean, like, what steps do you think can be taken if this case is decided and, like, the prosecution wins? I mean, there's no reforms that will necessarily happen, or even if they do win.
I don't know if I would say that this case will control whether or not there is prosecutorial reform. In my mind, you want to have as many different tools in the bag to hold people accountable for their actions, in a reasonable way. I mean, I think the argument that John is bringing forth and that his lawyers are bringing forth is, we agree there should be a high bar. This should not be easy, but there should be a bar that can be overcome, where a DA's office can be called on the carpet to answer for egregious dereliction of duty. Now, there are a number of prosecutors. In fact, the former Solicitor General under George W. Bush, Paul Clement, is leading an amicus brief, a friend of the court brief, on John's side, with a number of very, very senior federal and state prosecutors from the Republican and Democrat camps. And they've joined in John's argument because they, as prosecutors, believe that that's how a moral prosecutor runs his or her shop, and that's very important. So the first thing that I think is really important to say is there are a lot of great prosecutors out there, and there are a lot of people that do their job the right way and wouldn't have gone for the convenient conviction and the way that it happened here. I think open file discovery is a very important reform that prosecutors should consider putting into their offices. I think there should not be any reason to hide facts or witnesses or people who know things. I think the jury should be able to sort that out, and the lawyers should be able to discuss that. And reasonable minds may differ about the application of certain facts, but that's why we have a trial. And so I personally think that open file discovery is something that everybody should embrace because it will lead to the right result more often than not. I think that it's important that prosecutors' offices not keep score by convictions. And one of the challenges that we have as a society is that we want tough on crime prosecutors, and these guys are elected officials, and we hold them accountable for stats. That's a dangerous thing. We do it with our police officers, we do it with our prosecutors, and those stats end up carrying the day for how people get rewarded or not. And that's a dangerous thing to do when you then want somebody to be thoughtful on a case-by-case basis. So I think there's a lot of room for reform regardless of the outcome of this case, but I think this case is important because the more tools we have to force that reform, the more effective it's going to be.
If the Supreme Court rules in favor of the New Orleans DA, isn't that essentially them validating all the horrible things that they did?
I don't want to put those words in the Supreme Court's mouth. I think the Supreme Court is going to look at this case and decide whether or not, as a matter of constitutional and federal law, we have a body of law that says that a municipality can be held liable for policies that deliberately caused an injury and under what circumstances. That's the legal question that they're looking at, and they're doing so through the prism of the facts of John Thompson, which is why I think the book has some importance that I didn't know it would have when I started writing it. I don't know that it's necessarily a validation or not of Connick's actions. The Supreme Court makes a lot of things where they say this is really bad, but the Constitution doesn't give you a remedy. You got to get that from Congress. And so not everything goes to the Supreme Court, even though we think a wrong has been done. In the back.
I just have two questions. My first one has to do with, was any of the evidence, did that lead them to finding any additional suspects, or was there ever any resolution to the case itself, or is that in the process? Your story?
Yeah, so in the trial, in the 2003 trial, what Michael and Gordon tried to do was not only show that John was innocent, but explain what they thought had really happened that night. And the theory of the case that they put forward was, remember I said a witness had seen somebody running away from the scene holding a pistol. The person that he described was a 6-foot-tall African-American man with close-cut hair. John Thompson was 5'8", and you'll recall from his picture he had a fairly large afro. Kevin Freeman was 6 feet tall and went by the street name of Kojak. And with the new witnesses and the theories of the case that they were able to put together, along with conflicting statements that Kevin Freeman had made at different times to the police, the prosecutors, other informants, et cetera, they put together a picture that seems pretty clear that Kevin Freeman was there acting alone and committed the crime, sold the gun to John, who was a fence and traffic and stolen merchandise, and then pinned it on him because he could connect the gun to John. Kevin Freeman was killed in 1995 trying to steal a car from an off-duty New Orleans sheriff, and so he was not available to sit for the trial, and he was not available to give testimony, and so I can't say for sure that he did it because, of course, truth is what the jury says it is, and this is a book about truth, but that's certainly Michael and Gordon's belief.
Okay, and my other question was, what effect do you think the book might have on the case, if any?
I think the Supreme Court's probably pretty good at ignoring first-time authors in the decisions of constitutional law. I hope that what the book does is inform and educate people about some of the issues. I think the issues are important issues, and if the book is not more accessible than all of the court transcripts, then don't read it, because I've done a bad job. But I think it's able to provide the information in a more accessible way on some issues that I think are important. But I don't think it's going to, Scalia's not going to change his mind after reading my book.
We have time for a couple more questions.
There's a guy in the back who's been raising his hand for a long time.
I was just wondering, I mean, it seems like a really, really interesting topic, and I think a lot of people, if they heard about the book or read it, they would, really want to know why this type of thing happens. Do you see this moving towards movie time anytime soon? Do you see movie rights out of this?
Boy, I would hate that.
You would hate it.
No, I'm kidding. That would be great. We'll see how it goes. I mean, one of the nice things about speaking to this audience is, the book has a Facebook page. I've just launched a website. I think as a first-time author, the media campaign behind John Hollway and behind, say, Stephen King, they're not exactly the same. So that's one of the reasons for going around and having conversations like this with different audiences. I mean, I have found that the book resonates with people kind of across the political spectrum, which has sort of surprised me. I'm not surprised that it resonates with the anti-death penalty crowd. What has been more of a surprise and very gratifying has been that there are an awful lot of people on the more conservative side of the spectrum who are very concerned about government overreaching, and the fact that this isn't just John Thompson, it isn't just Booker Diggins, it's your sister or your brother or your boyfriend or you, and there's really nothing that protects any of us from circumstantial evidence and missed eyewitness testimony and a prosecutor that needs to get a conviction on a case, except chance. And so I think it's important to spread that story and for people to think about it in that way. And I would encourage all of you to talk to people on the bus or wherever you happen to be. But come to the Facebook page, tell other people about it, and the more people that know, the better off we all are, I think. Yes, sir.
Well, I am on the anti-death penalty side, so it definitely did resonate with me. And working with other death penalty cases, what we see is that a lot of the problems that you point out here are systemic. We know that the death penalty doesn't deter crime, that it punishes the poor, that it's racist. I would say it's cruel and unusual punishment. You're more likely to get the death penalty if you're black than if you're white. This was obviously a case where you had a black suspect and a white victim. But I was wondering, what was your kind of views going into this? Had you kind of already, did you already sort of have a perspective on it? Did this change your mind, or what was your sort of personal feeling?
Yeah. So the question is, what was my view on the death penalty going in, and what's my view on the death penalty now? If I'm summarizing that fairly, I was probably more like Gordon than like Michael when I went into this. I wouldn't have described myself as a fan of the death penalty, but neither was I a rabid anti-death penalty person. But I did think that it was vitally important that before you take the ultimate punishment, that you give it the ultimate defense and you really put it through its paces, because that's not a punishment that you can take back. I think I've come personally to think two things. The first thing is, regardless of your views about whether somebody can or should be put to death for anything they do, we're not doing it right. We're not administering these cases right. The error rate's too high. And I'm just not comfortable with having the death penalty be around if we're going to administer it in this way. The other thing that I personally have come to believe is that the death penalty is actually more about us as a community than it is about the people that are being executed or the victims. I think it's really important to mention here that the death of Ray Liuzza was a tragedy no matter how you cut it. There was no reason for that man to die, and he was murdered. And And there needs to be a punishment for that. We can't let that go by. But whether we as a society need to put that person to death, I think we should at least look at ourselves in the mirror and say it's about how we feel about it and not about what was done or how the victim's family feels or any of that. It's about us as a community, and that might change how we feel about it a little bit. It did for me. Realizing that my feelings about the death penalty, the way I looked at it, were all of a sudden, it was about what I think is fair for that murder. And so that's tough for me. But I think you can take all of that aside and just say, I think it's very hard to disagree with the assertion that if you're going to execute somebody, you ought to make sure it's the right guy. And if you can't do that, then you should find some other punishment.
Thank you so much. A few more credits. I want to thank Ernesto Valencia, who has helped us out greatly with all of the digital production work, as well, and setup for production, as well as Thomas Berry, who's been helping out this week as well. And I said that I promised Steve Olympio that I would do, where is Steve? A shout out to him for the poster design, so thank you, Steve.
Oh, the posters were great, thanks.
John's going to be